morning and welcome.
Good morning. May it please the court, I'm Roger Manus. If I could reserve 4 minutes for rebuttal.
Yes, sir.
I think that will probably suffice, but I've been here over the course of 40 some odd years. It's the first time I've ever heard an appellate reserve 90 seconds.
Yeah, well, it was the first one for me as well, so I wasn't sure our clerk's clock would allow that, but obviously it did.
So, may it please the court, this was an interesting case. Colonel Ronald Perry lived an interesting and colorful life, I would say. Decorated Vietnam War veteran, left the service of the United States and went to work for Sikorsky, designing helicopters. Had personal tragedies along the way, lost a son to an accidental gun death, and his life was interesting and colorful. It ended somewhat poignantly, I would say, and sadly, in 2020. But the reason I'm here today, I would say the crux of this matter, trial courts can abuse their discretion in different ways. And this new trial judge, I think, abused her discretion in this matter by applying an incorrect legal standard. My name is on a number of opinions coming out of this court involving undue influence cases. Some of them involve inter vivos transactions, and some involve testamentary instruments and transactions. But one thing that I think is fairly well settled in our law is that the determination of whether undue influence exists is essentially a step-by-step or check-down analysis, to use a football term, I guess. Without a preliminary finding of a confidential relationship, then there can be no undue influence. So the court has to make a determination of that there is in fact a confidential relationship, which is essentially a dominant and dependent relationship. The cases are abundant that hold that, and that finding, I think, serves as a predicate to the subsequent analysis. Once that finding is made, then after that, any transaction that occurs that favors the dominant party is presumed to be the result of undue influence, and that presumption can only be rebutted with clear and convincing evidence. So,
Counsel, can I ask you a question? I want to make sure I understand the order in this case properly in terms of what's before us. Has the trial court judge in this case, the trial court indicated there was not a confidential relationship, made that determination.
Right.
And has the trial judge also found that even if there was a confidential relationship, there was no undue influence in this case?
Well, that's correct.
Okay.
She did make that finding, but that's premised on having essentially gotten the cart before the horse on it, because what the trial court did in this case was commingle the undue influence analysis. She essentially turned the determination of a confidential relationship into a transactional analysis rather than the analysis of a relationship. A confidential relationship is a relationship. It's something that doesn't exist one day and then vanish the next day. That's not how it works. That may be that a person's cognitive ability may vary from day to day, but if there's a relationship where I am the dependent party and my spouse is the dominant party, that's a continuum, and so that determination has to be made. There's an abundance of evidence, and I don't think that's really in dispute in this case. This court nor the trial court had to look any further than Ms. Severine's testimony.
Counsel, you stated the issue before us presented it for appeal is whether the trial court erred in finding that a confidential relationship did not exist between Colonel Perry and Ms. Severine. Let's say let's assume for purpose of argument the trial judge was wrong to get into the undue influence that shouldn't have, it was putting the cart before the horse. Did you need to raise that as a separate issue in this case? Do we have an independent ground for the trial court's conclusion in this case with the determination that even if determination, there's no undue influence here? Or is that still fairly before us in this case?
I think that's before you, and I anticipated that question, and here's why I think that's the case in this instance. And I'd like to read, if I may, and I'm reading essentially from page 16 of the brief of Appellee, which contains a quote from the trial court's analysis on it. There was simply no showing that Mr. Perry's free will was overcome at the time he made the bank accounts joint with his wife on April 3rd, 2019 and November 26th, 2019. Now, the problem with that is that turns the analysis upside down. If a confidential relationship, dominant dependent relationship existed, which it did plainly, between Colonel Perry and Ms. Severine at the time of those, then the burden shifted at that point. We weren't required to prove anything at that point. All we had to prove was that the transaction occurred and that it favored her. At that point, the burden shifted to the defendant in the case, Ms. Severine, to come forward and prove by clear and convincing evidence that the transaction was fair. And our cases almost all say that the way you do that is by proving independent advice. There's no evidence of the fairness of these transactions whatsoever in the record. So essentially, by erring, trying to avoid using a colloquialism, by botching up the analysis of whether there was a confidential relationship in the first instance, the court then derailed, if you will, the order of proof of whether there was a undue influence, because once that determination, once there is an existence, the proof rather of a dominant dependent relationship, which we think there is an abundance of evidence for, I don't really think that's disputed. Ms. Severine testified that he was both dependent on me mentally and physically, and that at the time of the creation of the powers of attorney in April of 2019, he wanted me to be in charge of him. She also testified that he had been weakening and had significant physical and mental weakening before that, but he started having flashbacks at that time, and that's when he really got sick, according to her. So these transactions occurred after that. It just seems to me that the problem here, and I anticipated that would be a question from the court, is that the order of proof just basically turned upside down in this matter, and that the proper order analysis, method of analysis, or step-by-step analysis would be to determine, was there a dominant dependent relationship? If so, any transaction that occurred after that favored Ms. Severine is presumed to be, and it's a strong presumption because it's presumed to be the result of undue influence and can only be rebutted with clear and convincing evidence. And all of the cases say, virtually all the cases say, the way you prove fairness is with independent advice. And that's simply, that was just a breakdown in that analytical process by the trial court on this matter. So we were not, the trial court seemed to impose on the plaintiff in this case the duty of proving that at the time of these transactions, the transaction that Colonel Perry's conscious will was being overridden by Ms. Severine, but that's just not how it works. Judge Koch, in his opinion from this court in the estate of Pauline Maddox, notes, and I think we all know this intuitively, that there's almost never direct evidence of undue influence. It always has to be proved inferentially, and that's why the presumption exists. Is that once we get a relationship, burden shifts, and then the burden shifts to the dominant party to prove the fairness of the transaction. That simply did not occur in this case. So does any of the members of the court have any questions for me?
If we agree with your argument, and that's a big if, what do you want this court to do? Do remand for the trial court to make a new determination of what assets were and were not transferred because of undue influence?
I think that would have to be the case, Your Honor, and I don't, the parties had, this is a bench trial, so the parties had a full and fair opportunity to present the proof. Ms. Severine did not present evidence of the fairness of these transactions. I think then it just becomes incumbent on the trial court to enter a judgment consistent with the determination of this court that the trial court had erred in that situation, which in my mind would be mostly a mathematical computation. Right. So because all of these transactions that are in question occurred either on or after April 3rd of 2019. So.
All right, thank you, sir. We'll hear from you on rebuttal. Good morning, sir.
Good morning, Your Honor. Nathan Hunt, Montgomery County Bar, on behalf of the appellee, Lisa Severine. Wanted to address a couple of things that were brought up in the appellant's argument. Going to use the same term he used, cart before the horse. Opposing counsel just indicated that there was a dominant independent relationship and that the court got the findings out of order because there was this dominant independent relationship. Respectfully, that's not what the court found in its ruling. The court's order is very detailed on the testimony that the parties provided at trial, the testimony, there's a number of independent witnesses, including some of the decedent's children who testified at trial, and the court went through all of that testimony. And in a case like this, when you're talking about undue influence, or you're talking about some kind of confidential relationship, it's so fact-driven. It's so dependent on the credibility of the witnesses, what the proof was at trial, and respectfully, the proof at trial just didn't establish that there was a confidential relationship. And that is the first step. I agree with opposing counsel. That is certainly the first step in the analysis is there a confidential relationship? Where I do respectfully disagree is the court went through, starting on page 5 of its ruling, it started confidential relationship, and then it went through the two potential types of confidential relationships that we could have in this case. One of those being a familial relationship that rises to a confidential relationship or a legal confidential relationship. In my brief, I spent 1 page on legal confidential relationship.
It's my understanding there's no dispute of fact that she did have his power of attorney, but she never exercised that power of attorney. That
is correct, Your Honor. And that's why in my brief I spent 1 page on legal confidential relationship. But to address that court's question, one interesting thing about that, if you look at the original complaint that was filed in this matter, it was almost solely about Ms. Severine had a power of attorney over her late husband. That creates this relationship. It's inherently confidential. And then it would be the burden of Ms. Severine at that point to overcome the presumption to show that it was a valid transaction. The problem is, once the proof came out through party depositions and the proof came out at trial, it was that, sure, there was a power of attorney, but that power of attorney was never exercised by Ms. Severine. So then the plaintiff had to sort of pivot off of the power of attorney argument and then look at this familial or relationship to create that confidential relationship.
Counsel, I want to ask you the same question I asked opposing counsel. I want to make sure that I'm understanding the trial court's order properly in this case. am I correctly reading the order that we have the determination, no confidential relationship, but that the trial judge then proceeded to do an even if analysis? Even if there was a confidential relationship, then I find that there's no evidence here of undue influence. Am I reading the order correctly that way? Am I misreading the order? Is that what this order, how this order is laid out by the trial court judge?
I believe that's how the order is laid out. And the only thing I would respond to that, I believe you are correct, Your Honor. The one issue there is I think the court is saying, even if you take, and you would ask the opposing counsel this question, even if you take undue influence as a separate argument from confidential relationship, the court addressed whether there was just any undue influence at all, independent of the confidential relationship analysis.
Okay. Given that, the issue that's presented is by appellant whether the trial court erred in finding that a confidential relationship did not exist between Colonel Perry and Miss Everine. Do we have a complication here in this case then in considering, and is there an independent alternative ground that is not before us encapsulated in that issue?
Well, I believe as far as the undue influence argument.
As far as the undue influence,
Sure, sure.
as treating that, if we're understanding that as an even if,
Right.
there's no evidence of undue influence, does that need to be a separate issue, or in order for that not to be an alternative ground that we would uphold the trial court's order based upon?
Right, and that's why in my brief I addressed it as an entirely separate argument from the confidential relationship argument, because I did read the court's order to say that that's a final order on if there's any undue influence at all, even if it's a separate argument. I think the court was just covering all of its bases in its argument, but I believe the primary argument is, was there a confidential relationship that existed, and if so, you would look at the fairness of the transaction. But I think the court said if you take undue influence independently, the court heard all the facts of the case and said, even if you take it independently, we don't have undue influence here. And again, that's...
And you would read that as an alternative ground for the decision?
I would. And the reason I'm comfortable saying that is the court specifically addressed it in its final order as well, which Your Honor was asking, and the court made specific findings in its final order about undue influence. The timeline is so important in this case. Starting in April of 2019, that's when the power of attorney was done. And John Crow, the attorney in Clarksville who prepared the power of attorney, he testified in court. And there was all of this testimony from one of Mr. Perry's daughters, Lori Hadley, about, well, I started noticing maybe in 2017 or 18, he started to have a diminished capacity or a weakened capacity. But in April of 2019, he goes to Mr. Crow's office and does a power of attorney. Mr. Crow did a mini mental status examination of him before he let him do the power of attorney, and he passed that mental status examination. I asked Mr. Crow, I assume you found him to be competent if you let him execute a power of attorney, and he said, I found him to be competent. I let him execute that power of attorney. That was the same day that Mr. Perry and his wife, my client, went to the bank, and she was added to one of those bank accounts. We're literally talking about the same day an attorney performed a mental status exam, found him to be competent, allowed him to execute a power of attorney, and then they went to the bank and he added her to his account.
The attorney by that point, though, had been concerned for years, right, about this relationship. I mean, all the way back to 2015, if I'm remembering correctly, about, and you know, husband comes in and seems to be saying, I'm worried and he already has, does he already have a dementia diagnosis at that point, or?
The testimony from Mr. Crow was he being Mr. Perry, the decedent, had expressed that he thought he might. I don't know if he'd been diagnosed with anything.
So there's concerns back to 2015, and he's already expressing concerns 4 years earlier about my wife might try to change this, and 2019 there's the test administered by the attorney in the office where there's a long-standing concern here, and how do we look at those two things and understand those two things in relation? And
here's the issue, and certainly I think if they had gone to the bank after that meeting with Attorney Crow and she'd used the power of attorney to add herself, we have a entirely different analysis, but that's not what happened. Mr. Perry did that himself. And I think to sort of answer the court's question even further, I had indicated in my brief I'd gone through all of these other transactions that the decedent had given to other family members, and I had done the math this morning. It totaled almost $200,000. And I asked the plaintiff, who's the executor of the estate, why didn't you, if you're saying that he didn't have capacity or that he was in this weakened mental state or diminished capacity that they seem to be arguing, did you look at these other transactions? Did you decide whether these other transactions were valid? Did you need to file suit on those? And respectfully, he didn't want to answer the question, but he did. And he said, I didn't really think about it because those were given to the children. So it's really, it's a cherry picking analysis. They took 2 transactions in 2019 and said these transactions were not good transactions. Meanwhile, he sold a very, very valuable family farm in June of 2019. He signed the deed for that farm. He used those proceeds to give 2 $50,000 gifts to one of his daughters, to give hundreds of thousands of dollars in gifts to other children and grandchildren.
That sale was also, that was a below market sale that was made?
It was, Your Honor. But it was still a for value sale. It may not have been a fair market value sale, but it was a for value sale. And the issue there is, again, it's the best term I can come up with. It's like a cherry picking analysis. They took an April of 2019 transaction with my client and her late husband in a November 2019 transaction. They skipped June to November when there was hundreds of thousands of dollars given to other family members. They weren't worried about those transactions because those were given to children or grandchildren. They were only worried about the 2 transactions involving my client. And the executor should have had a duty, if he was that concerned about it, and he was a child of the decedent as well, he should be exploring all of those transactions, not just cherry picking certain transactions that had to do with my client. I did ask the executor as well if he was present for either of those transactions involving my client where she was added to the bank accounts, and he said he was not. So he had no independent knowledge of that whatsoever. That's in the trial transcript, and that is in my brief as well. One interesting thing I would point out too, when in November of 2019, when my client and her husband went to the bank and my client was added to another account, her daughter, the decedent's daughter, Lori Hadley, took them to the bank that day. She testified she understood why they were going to the bank that day. One of the questions Your Honor had asked is, a little bit about my client's interaction with her late husband and concerns about that. Well, I asked Ms. Hadley, you took them to the bank in November of 2019, is that correct? Yes. And she understood why they were going to the bank. Her father was adding his wife to that bank account. So she didn't stop that transaction. She didn't refuse to drive them to do that. And I sort of asked her a number of questions because she had expressed some concerns about her father's mental capacity. But I sort of pushed back a little bit and said it wasn't so much concern that you weren't willing in that time period to take 2 $50,000 gifts. I actually called one of them a loan to try to give her a little cushion, and she corrected me and said those were both gifts. So within April of 2019, when the first transaction occurred with my client, in November 2019, Miss Hadley, one of the daughters, received $100,000 as gifts. And she testified that her father's intent, I think this might answer Your Honor's question a little bit, her father's intent was very clear in those transactions. So when they're talking about Mr. Perry having a deceased or a diminished capacity or that he lacked capacity, his daughter was saying, well, when he gave me 2 $50,000 gifts, his intent was very clear. But yet in April, when he passed a mental status exam, and in November, when she drove them to the bank, suddenly there's all these concerns about that. But when she was getting gifts, her children, the decedent's other children were getting gifts, there was no concern at that point in time. So I keep using, cloak. You can't have your cake and eat it too. You can't say these gifts were all okay because they're children and grandchildren. One of the grandchildren got an F-250 pickup truck. I mean, there were all these cash gifts that were given by the decedent to his family members, and the executor didn't file suit for those. He didn't have any concern about those transactions. His concerns were about the 2 transactions that were given to the decedent's wife. Those were what his concerns were about. And we keep talking about the decedent's diminished capacity, and I do agree with counsel. My client did testify, I think in her deposition and at trial, that at the end of his life, certainly, which I believe he passed away in July of 2020, at the end of his life, he certainly did have a weakened state and a weakened capacity. But what we're talking about is transactions that happened a year or a year and a half before that. And certainly he was still coming to Tennessee at that point in time. He was still conducting business. He did a power of attorney. He sold a family farm. he was still doing all sorts of transactions a year or just over a year prior to his death. So certainly, just like in a lot of occasions involving elderly people, at the very end of his life, he may have had some type of diminished or weakened capacity. But those transactions with my client didn't happen at the end of his life. They didn't happen in 2020. They happened a year or a year and a half prior to that. So that's the time frame that we would be looking at. But if you don't get past confidential relationship, according to the appellant's argument, you don't get to the next step. We don't have a legal relationship. She never used the power of attorney. So by itself, that wouldn't be enough. You have to look at the familial relationship. And I cited in my brief, when you're looking at familial relationship, being a child or being married to that person is not enough. You have to show more. And that's where it's so important in this type of case to defer to what the trial court its ruling, and that's why there's a preference given to the trial court's ruling, because it heard all of those witnesses. It assessed the credibility of all of those witnesses. And Chancellor Lund may have been a new judge at the time, but her order is very, very detailed about each step of that process. And it even talks about, when it looks at undue influence, it sort of looks at what the factors of fairness would be. It analyzed each factor of fairness under undue influence and found that it would not meet the necessary burden to prove the plaintiff's case anyway. So I think if anything, the court was overly cautious to cover every possible argument that the appellant might have, and just found that the facts did not support it, and specifically that the plaintiff did not meet their burden to show that there was a confidential relationship, so you would never get to the next step of the process. Thank you.
Thank you, Mr. Hunt. Mr. Manus?
I'm constrained to point out a couple of areas which I think counsel strayed away from the record, and for which there was no, actually made factual assertions which were incorrect. Ms. Hadley did act as a cab driver for Colonel Perry and Ms. Severine to take them to the bank. I don't believe there's any, I'm fairly certain that there's no evidence in the record. In fact, I think she testified that she didn't know what kind of transactions they were engaging in that day. So I think counsel has extrapolated evidence that's really not in the record in respect to that. That's just simply incorrect. Now, I'd like to address a couple of things in the short time I've got. One, Judge Usman has raised this issue, and I'd like to address that about the independent alternative grounds. Could the court, and did the trial court attempt to do that very thing? And I think the answer is yes. That's what the trial court attempted to do. And the way the trial court could have done that was make a finding that even if there had been a confidential relationship established, that the transactions were proved to be fair. And this is how they were proved to be fair. But that's not what the trial court did. What the trial court did was say, there's no proof coming from the plaintiffs in respect to those transactions that there was any direct undue influence, that his conscious will was overridden that day. And that's just simply inverting the process of how you establish a lack of undue influence.
Counsel, excuse me for interrupting. Assuming that the trial court made an alternative determination with regard to undue influence, does that translate into the issue of undue influence is properly before this court?
Well, I don't think so, and I tried to address that as best I could in my primary argument today. In my mind, once this case got off the rails in respect to the finding on no confidential relationship based on something, an individual transaction analysis, then everything that happened after that basically was erroneous. And so it just seems to me that it's a question of which step has to occur first, And if the trial court erred in its finding of no confidential relationship, that everything that else that followed from it, based on the analysis that the trial court went through, was erroneous. So,
Thank you.
thank you. So, one other thing I'd like to address in the minute that I have left is this issue regarding the gifts. Colonel Perry did not make gifts to Miss Hadley and his daughter, Carol. Colonel Perry and Miss Severine made those gifts, according to Miss Severine, that she was completely involved in that process because she considered the money to be hers. She said they were joint accounts, and so I had a right to make the decisions or to participate in the decisions. And so it's completely different. I mean, it's apples and oranges in terms of who made those gifts. Miss Severine made those gifts every bit as much as Colonel Perry did. She had the discussion, she wrote out the checks, and he signed them. And so that's how that went. And that's something of a red herring, I believe, that was fed to the trial court and has been argued to this court since then. So I'm out of time, it appears. Any questions that I could answer before I sat down?
Hearing none, Mr. Manus, thank you. Thank you, Mr. Hunt. We will take your case under advisement. The fourth case on the docket has been continued. That concludes the morning docket.